Good morning, viewers. Welcome to this law lecture series. Today's topic is WRIT jurisdiction under the Constitution of India. First part in English. Very soon you will have Hindi version of this lecture also. Here is the synopsis of this topic. Synopsis may be used by you as a short notes or as a revision sheet. The topic has been divided in 3 subheads. The main head is, you see, a brief evolutionary course of high prerogative writs. A brief evolutionary course of high prerogative writs. This main head has been subdivided into 3 subheads. A, B, and C. First subhead is WRIT jurisdiction under English law. The second subhead is WRIT jurisdiction under British India. And the third one is WRIT jurisdiction under the Constitution of India. So the main head is brief evolutionary course of WRIT jurisdiction, subdivided into 3 subheads. First, WRIT jurisdiction under English law. Second, WRIT jurisdiction under British India. And the last, WRIT jurisdiction under the Constitution of India, independently. Now the first subhead, WRIT jurisdiction in English law. England is the birthplace of WRIT jurisdiction. Note it well. England is the birthplace of the WRIT jurisdiction. WRITs originated for the first time in England. How? Let us see. The British Crown was regarded as fountain of justice. Fountain of justice means a person who administered justice immensely. So the British Crown was regarded as fountain of justice. He issued high prerogative writs to protect the interests of his subjects. High prerogative writs means super commands of the British sovereign. We only say writs, but its full and historical name has been high prerogative writs. You must learn it. High prerogative writs means extraordinary and supreme command of the British Crown. The 13th century is remarkable. In the 13th century, writ procedure was reflected, noticed for the first time. First reflection of writ jurisdiction was noted in 13th century. Few centuries later, By the end of 17th century, the writ jurisdiction in England was fully established as a popular mode of judicial review. Now come to subhead B. Subhead B. Writ jurisdiction in British India. The Regulating Act 1773 was enacted by British Parliament in 1773. By this Act of 1773, a Supreme Court at Calcutta was established. And the Supreme Court was conferred with writ jurisdiction, limited writ jurisdiction. Not like that what we see today under Constitution of India. The Supreme Court at Calcutta had 4 judges, including the Chief Justice. It consisted of 1 Chief Justice and 3 puisne judges. Puisne judges, junior judges, companion judges. The judgments and the decisions of the Supreme Court at Calcutta were not final. A person aggrieved by its judgment or its decision had a remedy by way of appeal. Appeal lay to the King in Council at England. So King in Council at England was the appellate authority. Now the second act. The Indian High Courts Act 1861. By this act, the Supreme Court at Calcutta was abolished. So Supreme Court at Calcutta was established by the Regulating Act of 1773 and it was abolished by the Indian High Courts Act 1861. The Indian High Courts Act 1861 established 3 high courts in British India. The first one, the High Court of Judicature at Calcutta. The second one, the High Court of Judicature at Bombay. And the third one, High Court of Judicature at Madras. And all the 3 high courts, these 3 high courts, were conferred with writ jurisdiction. The decisions of these high courts were not final. Any person aggrieved by the judgment or decision of the high courts had a right of appeal. The appeal lay to the Privy Council at England. Appellate authority was Privy Council. At that time, the Code of Criminal Procedure 1872 was in force. The code was amended keeping in view the writ jurisdictions of the three high courts. Adjustment of the Code of Criminal Procedure 1872 to the writ jurisdictions of the High Court. To that end, the Code of Criminal Procedure 1872 was amended. Now let us move to the C part, subhead C. Writ jurisdiction under the Constitution of India, under the independent India. We have taken the writ law from England, but here one has to be very careful. Note it, we have borrowed writ law from England, but only analogy has been derived. Basic principles and general principles as to writs as prevalent in England, that have been taken by the framers of the Constitution. The framers of the Constitution have not blindly adopted or accepted or incorporated the English law as to writs. You see, the two societies are greatly at variance. English society and Indian society are not comparable. The cultural differences, the economic positions, and other relevant factors were taken into account, and so a deviation was made. It was thought fit to give the Supreme Court and the High Courts a wider writ jurisdiction. So the writ jurisdiction in India is wider vis-a-vis it is under English law. Look here, Indian law wider than English law. Under the Constitution of India, we have two courts of records, only two. One, the Supreme Court under Article 129, and the other, the High Courts under Article 215. No other court in India has writ jurisdiction. Parliament has been given enabling power under Article 32, Clause 3. Note it, 32, Clause 3. Parliament has been given enabling power. In exercise of that power, it can confer writ jurisdiction to other courts also, other than Supreme Court. But without taking the writ jurisdiction of Supreme Court. It can't take away the writ jurisdiction of the Supreme Court. That has been held to be one of the basic features of the Constitution of India. So the Supreme Court cannot be deprived of its writ jurisdiction. But simultaneously, if the Parliament thinks fit, it can create new courts or it can confer writ jurisdiction on the existing courts. But so far, the Parliament has not exercised its enabling power under Article 32, Clause 3. So under Article 32, the Supreme Court of India has exclusive writ jurisdiction. It has not been shared by any other court. Yes, under Article 226, High Courts too have writ jurisdiction. The writ jurisdiction of the High Courts is wider than the writ jurisdiction of the Supreme Court. Supreme Court can issue directions, orders and writs only for the enforcement of fundamental rights and for no other purpose. But the High Courts under Article 226 may issue directions, orders and writs for the enforcement of fundamental rights and also for any other purpose. Any other purpose also. Here again, Article 139 is to be referred to. Article 139 is an enabling provision. 32(3) enabling provision. 139 also enabling provision. Under Article 139, Parliament has been conferred with enabling power to widen the scope of writ jurisdiction of the Supreme Court and to bring it at par with the High Court's writ jurisdiction. Parliament has not so far exercised its enabling power under Article 139. So the writ jurisdiction of the Supreme Court under Article 32 continues to be narrower than the writ jurisdiction of the Supreme Court, of the High Courts under Article 226. Parliament may enact a law and say, provide that henceforth the Supreme Court of India shall also be competent, have power to issue directions, orders or writs for any other purpose, like High Courts. But so far, the Parliament has not exercised its enabling power under Article 139. Writ jurisdiction is an extraordinary jurisdiction, not ordinary or alternative jurisdiction, not ordinary jurisdiction, extraordinary jurisdiction. And at the same time, it is discretionary in its nature. You have to note it very well that the writ jurisdiction of the Supreme Court under Article 32 and of the High Courts under Article 226 is extraordinary discretionary jurisdiction. If the party aggrieved has any alternative remedy, say institution of suit, civil suit, or preference of appeal, or making a revision application, then he should avail of those remedies. None can say that I can institute a suit, or I can prefer an appeal, or I can go for revision, but I will not go. And I will go directly to the High Court or to the Supreme Court under writ jurisdiction. No, that is not permissible. It is extraordinary jurisdiction and discretionary jurisdiction. Yes, one more important point. Writ jurisdiction affords quick, effective and inexpensive remedy. It is quick, it is effective, and it is inexpensive constitutional remedy. In exercise of its writ jurisdiction, the Supreme Court and the High Courts may issue any directions or orders or writs, including the writs in the nature of habeas corpus, writs in the nature of mandamus, writ in the nature of prohibition, and writ in the nature of quo warranto and certiorari. In a given case, more than one writ can be issued simultaneously. Court may issue certiorari, at the same time it may issue mandamus. So more than one writs can be issued in one and the same case simultaneously. There is no bar that in a case only one writ can be issued. This is all for today. Soon we will meet in the next lecture. Till then, goodbye.